Good evening. Good evening. Happy New Year. Welcome to Truth and Justice TV. My name's Jennifer Obaseki, and I'm so happy that we're here now in 2022. This new year, I'm sure that you are just relieved to see the back of 2021. I mean, what a stressful, impactful, in an adverse way and positive way, year 2021 was. But now we're embracing a new year. It's onwards and upwards, and well done for making it through to this wonderful, prosperous, health-giving new year. And I pray that this year, everything you ask for that is good will come true. Joining me today on Truth and Justice TV, I have the wonderful Miss Vivian Akimbanjo. Welcome, Viv.
Thank you. Hi, everyone.
Previously, Mrs. Akimbanjo spoke to you about family law, but today we are going to be talking about housing. Now, for some people, living in their current situation is precarious, or some people are actually facing homelessness or at the risk of homelessness. And we're going to be talking about homelessness, rent arrears, disrepair, and what you need to do if you're having a housing situation. So stay with us today. So first of all, Happy New Year.
Happy New Year.
And I hope you had a wonderful break.
Yes, I did.
Brilliant. And there are many people out there that either due to the pandemic or just due to their living situations may be facing a situation of homelessness. And what would you really say to anybody who's in that situation where they're either at risk of losing their property or they have no property?
My advice would be seek help, ask for help, reach out to anyone around you, the communities around you, to the citizens' advice, to your solicitors around you. We are here to help. So you're not alone in that situation. There are lots of options available to you.
Some people will be told, oh, it's difficult to get housing, you have to be eligible. But some of the myths around this area, number one, even if you don't have documents and you are at risk, you're a vulnerable person, maybe due to disability, or maybe you have children. Specifically children, you cannot be left homeless or without a roof over your head if you have a child. So there's a no recourse team in every local authority that is actually set up to help people who are not documented. So you can go to them for help. Anybody with a child has to be assessed not just under housing legislation, but also under Children's Act legislation. And if you're disabled, again, there are adult social services teams that deal with vulnerable adults. So apart from the fact that you don't have papers, that is not a barrier to you seeking help for housing. And then if you are documented, you're British or you have limited leave to remain, even if you have a no recourse cap on your leave to remain, you can apply to have that removed. You can apply to have a change in your conditions. And that can be done online, but does need supporting evidence. So evidence of your homelessness, evidence of your vulnerability can go with that. And then if you are documented, you're British or you have settled status, again, you have to be eligible. So people don't know what about, eligibility is. Just being homeless is not enough.
No, definitely it's not enough. You've got to be eligible. It's just like you claiming benefits. If you're unable to work or you're unwell, the government, if you go to the job centre, they would assess you. Likewise, housing. For you to be eligible, you've got to come under certain criteria. If you're homeless, for instance, or you're threatened with homelessness, probably your landlord has given you eviction notice, or you're living in disrepair, or the person you're living with has asked you to leave, you found yourself on the streets, you're homeless. If there's a threat of rent arrears over you and your landlord has given you the letter to say, look, I would want you to leave, you are threatened with homelessness. So yeah,
some local authorities may say to you, just stay there, wait for your landlord to take you to court. And, you have to be specifically homeless at the time you present, but they can open a case file prior to that final court order. And sometimes that final court order may come with costs. So you always have to make your case early to the local authority. Let them know when or if you are going to court, or the day that you're being told to go onto the streets, number one. And then number two, if they're saying to you, wait for the court to make an order, let them know that you cannot afford any additional legal costs. And if there is that liability put on you, it may cause you additional indebtedness. But some local authorities do say, even though you're homeless, you are not eligible for social housing. So the local authority may help in different ways. What different ways can you sort of explain that they may decide to assist?
If someone is threatening homelessness or homeless, and you contact a solicitor or your housing support worker, what they could do for you is to tell you, look, go to the council, call the council to say, look, I'm homeless. They could put you in a hostel, temporary accommodation. If they assess you, they will call you, assess you, speak to you, and find out your earnings. If you're not working, if you're working, or as long as you fit that criteria, you're vulnerable, you have mental health issues, or you're unwell, you have life-threatening issues, they have a duty to provide suitable and a suitable accommodation for you. So they may place you in a hostel. If you are going through domestic violence in your relationship, also you're fleeing from domestic violence, they could refer you to the refuge where you have temporary accommodation, while someone will maybe directs you to a solicitor or a support worker to help you apply for housing. So there are various ways.
So there could be a temporary provision, and then whilst you are waiting for a final decision. So the initial thing is the immediate need, you might be put in a temporary position, and it may not be local. It may be quite far away, but the fact is, if you are really homeless, you will accept what is on offer. But some people need support networks, need hospital treatment. So it's up to your representative to make those representations for you. What if you don't agree with the decision? What if they say, do you know what, we don't agree that you're homeless? What can somebody do?
Yeah, you can apply for them to ask them to review their decision, so they can go back and look at the situation to say, look, more times than one, they would go back and say, look, we now owe you a duty because they've reviewed it, they've seen your circumstances, you've submitted more documents, more evidence of your circumstances, and then they will look into your situation, probably put you somewhere temporarily while they look for a permanent one. Sometimes you may be put on temporary accommodation if you haven't got the support network for someone to support you and go after the council for them to move you into a permanent place. You could be there for like 6 months, a year or more. I've seen cases of 2 years in temporary, but the moment we've represented them, they've moved them onto another accommodation permanently.
Thank you. So do not despair. Number one, even if you're not instantly homeless, there is things such as technical homelessness, such as the accommodation you're in is not suitable, is not habitable, and therefore you may still have a roof over your head but be considered technically homeless. And you may be at risk of losing your housing, i.e. you may have a court date, been told to leave accommodation by a particular date. You still need to make your case. And even if the initial decision from the local authority is negative, you can ask for a review. If the review is not successful, you can also ask for an appeal. And all this while you're having the appeal and review, if your situation is most urgent, you can ask for temporary accommodation. So right now, we're going to take a very short break. And when we come back from the break, we're going to be talking about disrepair, where the situation in which you're living is so disastrous that you're having water infestations or vermin and different other situations which make the home not habitable or require instant obligations from your landlord to carry out repairs. And also we'll be looking at some other things such as rent arrears, and also with regards to challenges on defending possession proceedings. What can you say in response to somebody who might want their property from you and ask you to leave? What defences can you put in? All this after this short break. See you in a few moments. Welcome back to Truth and Justice TV. And today we're talking about housing. And within housing law, there's lots of different elements, but we're really focusing on those people who may be vulnerable and dealing with housing situations. Before the break, we spoke about homelessness, what you can do, whether you're documented or not documented, and how you can deal with challenges to decisions that may be rejecting you for permanent accommodation or a duty from the local authority to give you assistance. So we are now going to talk about the issue of disrepair. What is disrepair? Some people might think, oh, the tile has fallen down or the tap's not working. Is that disrepair?
Well, there are lots of things that could come under the term disrepair. Could be you're having a leaking roof. Could be that your hot water is not working, you've got mold in your property and different kinds of mold or damp in your property, or the door, the hinge is not working properly. You as a tenant, you also have a duty to repair, keep your property in good repair, so at least habitable, clean and nice and neat. But your landlord also has a duty to ensure that the pillars, the exterior part of the property and the major part of the property is in repair. For instance, if your hot water is not working, you've got damp all over the place. It's winter now, and there's something they call black mold that's really dangerous, can cause infections and diseases in the lungs. So those kind of things, your landlord has a duty to ensure that those things are repaired. And if it's been ongoing, you must let your landlord know. A couple of times at least by phone calls or by going on their websites, making a report on their websites, or by email, so there's evidence. So if they haven't done that, then you contact your solicitor for the assistance.
So a landlord has a duty to keep a property in good repair, must ensure that there's no water ingress or even water escape, and heat. There must be provision of hot water, and also no vermin, cockroaches, rats, etc. And we spoke about black mold. There's been this long-going debate: is condensation disrepair and is damp disrepair? And the answer is, it depends on how the water is coming in the property. So you might need expert assistance on that. And then the very good thing you was mentioning is about giving notice, because if the landlord reacts quickly,
problem.
You may not be able to get compensation, especially if the landlord reacts within a reasonable period of time and offers you to cover the cost of your basic damage. And if somebody does feel, though, that they've really suffered as a result of the disrepair, have extensive damage, what can they do?
Contact your solicitor, and then we'll contact the landlord to give them notice that, look, there's disrepair in the property. If they're not doing anything about it still, then we'll send a letter before claim, and to take them to court, ask them for the court to give an injunction for them to carry out those repairs, and also to compensate you for your income, for the inconveniences
and losses.
Sometimes this could have spirals or happened or occurred or continued for years, or months. And the longer it is, the more compensation you will get.
Yeah.
But hopefully, they will respond quickly to you out of that situation.
Okay. So disrepair, is it something that, and all these housing discussions that we're having, is it something people have to pay for their legal services for, or can they get any kind of legal aid to help them with their cases?
Of course, with disrepair, you can get legal aid. It comes under the scope of legal aid, so you'll be able to get that if you're means tested and maybe you're unemployed, you're not able to afford it. We'll do the legal aid eligibility calculation to see if you're eligible. And once you're eligible with your earnings and with your situation, circumstances, we definitely will cover that under legal aid. You will not have to pay.
I think some people get confused with legal aid. So sometimes they may be asked to pay a contribution?
Yes. Sometimes if you're working, because that comes under the scope of legal aid, and disrepair generally comes under the scope of legal aid. If you're working, they may ask you to pay a contribution. So it's just an amount in contributed to the work the solicitor is carrying out for you. So they will give you the amount you pay monthly until they're satisfied that you've paid a certain amount. They may ask you to stop.
I see. So it all comes down to the eligibility and how much the individual's earning. So back to the issue of, let's say, possession now. Let's say your landlord says, do you know what? I'm tired of you. Don't want you. Or I just want my property back. You need to leave. What are the correct steps that really should be taken? Can the landlord just say it in that manner?
Oh, your landlord is supposed to give you a notice, a written notice. Sometimes you're in private landlord section 21 notice, asks you to leave the property between certain days. Like now, because of the pandemic, the amount of notices have changed over the past years from like 1 month to 4 months. If you're in rent areas, even a shorter time, because you refuse to pay your rent. So your landlord is supposed to basically prescribed order in writing within a certain period of time and give you enough time to be able to look for somewhere else to live.
You don't help yourself, especially if you listen to bad advice or wrong advice. But it's very important that even if you think that, there's a pandemic and the court system is backed up, I don't need to pay my rent, my landlord, it will take time before they take me to court. Is that correct? It's not correct.
Especially the possession claims. It's not. They do it so quickly, sometimes without your notice. They could just do it. There's something they call the accelerated possession claim. So they could just do it without your notice, and then they send you the paper, the court order, the court decision that asks you to leave within a certain period.
So please don't put yourself in a position where you might be considered intentionally homeless, where even if the court order comes and you find yourself on the streets, you go to the local authority and say, look, I've got a court order asking me to leave my home, or bailiffs are now asking me to leave my home. And then the local authority do their assessment and see that you didn't pay your rent and the landlord had every right to ask you to leave the accommodation. That could be seen as intentionally homeless. So you don't want that kind of a decision. But let's backtrack a little bit. What if somebody's in arrears and then they are struggling, but they really want to clear their arrears or have any good intention anyway to try and settle with the landlord? Can they still say to the landlord, please review this?
Of course. It's not just straight on going to court. If you contact your solicitor or support worker to assist you with this, what they could do is, first of all, the first thing we normally would do is to contact your landlord to see if you can come to an agreement for you to pay back the rent arrears, convincing them that you are willing to pay, you're not evading payment. So once you're able to come to that agreement, most times the landlord would agree and say, okay, we'll give you more time to pay. But if you're not willing to pay, probably if you get into that agreement and you're still not paying your rent, then the landlord will have no choice than to go to court, get the court order.
Wow. So you have to be very careful. If you go to court and a judge also feels that you're being evasive deliberately and you have a possession order against you, if your landlord is coming not just for the property but also for the arrears, it could also put you in a really adverse position if you're looking to get another property. Even if you're trying to rent privately again, it may go as a hindrance against you because you may have not just your bad credit, but be seen by a new landlord as a highly risky tenant and therefore require higher deposits or even a guarantor. And can guarantors be at risk as well if they try to help people?
Of course. If you're standing for someone to pay debt generally and the person is evasive or has taken a runner, definitely they will go for the guarantor.
So you might put yourself and others who might have tried to support you at risk. So if you're asked to act as a guarantor, if you're asked to act as a guarantor for somebody, it's important that you try to, one, understand the individual that you're putting yourself out for, and two, realize that you are indeed putting yourself at risk of liability for that individual's debt and rent arrears. Sometimes, parents do this for children that are going off to study and rent rooms at university, which is understandable. But when it might be a person that you're trying to do a good deed for, you really, really have to be aware of the fact that you could be held liable for their debt. Now, before we conclude today's session, in relation to we've spoken about disrepair, we've spoken about eligibility for housing. Are there any other things with regard to housing that have come up recently? What of people who are at risk due to, for example, threats and bad activity within their communities?
Yes, for instance, with family that have been threatened by gangs in their area, they automatically being referred if the matter has been referred to the police would advise them to move from the area automatically, so they come into priority in the housing list, probably from their landlord. First from their landlord. The landlord has a duty to move them to a safer area, to another area, so for their safety. And then the local authority has a duty also to provide accommodation for them. So if you're in that situation and you're threatened with maybe gang violence or attacks from people to your family, to your son, to your daughter, you have a right to report to the police, and then to your landlord, they would escalate your situation and move you to another area. Even the local authority will come in and try and help you to move to another area. They all have a duty to ensure you're safe.
It's really important that you don't leave your family at risk. And if you're being told no, and you know that there's been threats, incidents, police reports, and you're not getting anywhere, please do reach out for help. As you've heard, if you're in social housing, there's an immediate duty on your landlord to move you to a safe area. And then incumbent upon that, additionally, is a duty by the local authority to make sure that you and any child within your household is safe. So it's a twofold test. You may need to ask police liaison officers to provide you with letters. That can sometimes be difficult. I know that the police at times say, yes, report to us. But if you're in a situation, even with the police, where you're not getting the follow-up supporting documentation that you need, again, reach out so that you have legal advice and assistance to try and ensure that you're not left vulnerable, or no children in your household are left vulnerable. Well, thank you once again for coming to Truth and Justice TV. And if people want to get hold of you, how do they do that? How can they contact you?
You can contact me by sending an email to vivian@obasekisolicitors.com, and we'll respond. I'll respond as soon as I can, or info@obasekisolicitors.com. You could also call us on our numbers on the screen, and I'll get in touch with you as soon as I can.
So you've heard it there. If it's homelessness, then definitely you have to make sure that you try and do an application. Make sure that you do not stay vulnerable. Street homelessness, in this day and age, there is absolutely no need for it. Once you report to the local authority, a team usually makes a visit to see that you are telling the truth, that you are street homeless. Even if they make the visit and don't find you because you've had to go and seek food or seek some kind of resource, the application is still there. They must do an assessment, and if the assessment must be done properly and reasonably. If you don't like the decision, you can ask for a review, and there is also an appeal system. You can appeal to the county court if you don't like the initial decision so far as there's merit, and you may be able to claim legal aid to do so. Again, going on to disrepair, you've heard that not all situations are a case of disrepair, but if there's a lack of resources coming into the property, use of particular facilities like bathroom, toilet, if there's absence of those, or running hot water, it can be deemed as disrepair. And the incidence of black mold, as you've heard, can be very, very dangerous. So don't stay quiet on these issues. And then also with regards to possession, you've heard you must receive notice in writing and the proper amount of notice. If you're renting a room, that might just be reasonable notice and may not be the number of months that have been prescribed due to the pandemic, because a license is less of a tenure than a lease or a short hold tenancy. And again, if you're at the threat of violence, whether domestic violence or gang-related violence, you must seek help from your landlord in the first instance for a move, back it up with evidence from the police, and then go to the local authority also for assistance. So once again, thank you for joining us. And thank you, Viv. And we thank you also for staying with us. Again, Happy New Year. And make sure you be good till we see you again next week. And if you can't be good, be careful. See you next week. Bye.